what Sam talked about was the court of protection and work within the court of protection, and importantly, that there is a person at the heart of the court of protection. Importantly, however, we need to remember that if you're in the court of protection, chances are that their mental capacity is in question, if not already determined not to be there. So I'm going to go slightly off-piste on this point, and thanks, Ben, for giving me the soapbox to come in and talk to you today about things that sort of generally bother me, quite frankly. So I want to start off with the idea of P in the court of protection, but more widely, the idea that we have a person, in this case, Big Tom. If anybody wants to ask me why he's called Big Tom, I will tell you afterwards, but not public consumption. And there's always a supporting cast. There's always more people. You've got P in the court of protection protected party, or you've got somebody who is preparing, setting out their scenarios, trying to do their estate planning, trying to do something that's inevitably controversial. Maybe that's just me, but I had some clients this week, lovely clients, multi-generational family, absolutely delightful, with a very vulnerable grandchild at the heart of it. And they said, we don't understand why you're making things so complicated. And I said, because things go wrong. Because that's what I see. And they said, but you know us. I said, no, I said, actually, in fairness, I do know you, and you are one of the 5 clients I can count on one hand that don't have a complex scenario ongoing. And so we had a nice chat, and I said, you know, you are the poster children for normal families, and very much not what I normally come across. So when we're talking about P in the court protection, or we're talking about estate planning, or we're talking about anything of this nature, there's always other people. And it's the other people that are the entertaining part of this usually, because you've got your Big Tom character, you've got your P, and they will have views. They might not have views that you like. Certainly, you know, families are a delight, aren't they? You know, throw grief and money into the mix. Always a pleasure. But generally what happens in my practice area is this. I'll get a phone call. Dad's had a fall, Dad's in hospital, I don't know what to do. Right. I think I might have signed a piece of paper a number of years ago. I think it's called a power of attorney, I'm not sure. But the purpose of this slide, taken from doctors I was talking to, is this notion of dependency, independency, and frailty. And it's particularly a frailty point. And the top left-hand corner talks about what happens if anything happens to any of us. You fall, you break your leg, you get unwell, you have a dip. You know, you might go into hospital, you might have your leg set, you'll come home. The expectation is that you will go back to being functionally independent. There's a small gap where you're sort of off grid. What happens in older clients, more frail clients, clients with multiple comorbidities, is that dip is pretty serious. They're already bouncing around on the functional dependency, independency line, and then something happens. Something happens. It could be a stroke, it could be an infection, it could be a dementia diagnosis, it could be many things, but there's generally something that starts that cliff edge. And it's that space where the red cross is, where life gets complicated, because you've still got somebody who has views and opinions and agency and autonomy and opinions, and may or may not have capacity, may or may not have fluctuating capacity, but they are never going to get back to that independence point. And that frailty space is an interesting space to find yourself in when you're dealing with sort of vulnerable client work, because this is where I've got power of attorney, I'm acting as attorney steps in. There isn't a power of attorney. We need to go to court of protection to get appointed as a deputy. Or I've got a power of attorney, I know best. Because, you know, dad's lost it. Because he's had this diagnosis, because he's had this stroke, we'll just write him off. That is not the point of the Mental Capacity Act. The whole point of the Mental Capacity Act is capacity is task specific. We've heard Sam talk about that at some length. And this space is interesting. This space is an interesting place to be working with clients and individuals. Because if we go back to Big Tom, what does he need? What does he need now he's had that fall? He's had that diagnosis, that stroke, that frontotemporal dementia, the Lewy body dementia. And, you know, there's hundreds of types of dementia, and they all present differently. So it's really important when you're dealing with people with dementia, for example, that you understand what type of dementia it is, what those issues are. And it's not just about the court of protection. It's not just about what happens when there's a dispute. It's what happens on the day-to-day. What are his needs? How are those care needs met? How are they funded? What is his capacity? What is his capacity for? Can he manage his finances? Can he manage decisions about residence? Can he manage decisions about health? Is he amenable to a care package in place? Probably not. I've yet to meet anybody who wants to voluntarily go into a care home. So, you know, but sometimes that's what's required. Are the family in agreement? Probably not. Let's be honest. Do we need court protection involved? Are we looking at disputes? Are we looking at declarations of best interests? And then are we looking at issues of vulnerability? Now, vulnerability appreciates a bit of a word that people are a bit, well, we don't think it's quite the right word to use for people. I'm going to use it because it's the best we've got at the moment. And because Big Tom will be vulnerable. Big Tom will have vulnerabilities because of his illness, because of his infirmity, because of his frailty. And he's not going to bounce back. He's not going to bounce back like somebody who's 20, who's broken their leg playing football, who's going to be up and running in 6 weeks or so with a bit of physio. He's going to be in a space where there are lots of multiple and complicated decisions need to be made, and there will be supporting cast members going back to his family. If Tom has done his planning, Tom will have an attorney in place. If Tom hasn't done his planning, it's an application to court protection. And we were talking this morning about the sort of court's views of not wanting to be paternalistic when it comes to health and welfare decisions. Court protection applications for deputyships, if they're uncontested, they are a paper application. They're quite straightforward insofar as anything in the court's straightforward, but they are, in the scheme of things, quite straightforward. Health and welfare decisions made on the ground, made in best interest, day in, day out. We've talked about task-specific capacity. We talk about decisions that are made in the moment. If you've got a health and welfare power attorney and you've got that delegated decision-making, then you have better delegated that decision-making to somebody you know is going to act in your best interests. I had clients recently, and classic, mother'd gone out shopping one morning, she'd come home, and she had a massive stroke. And the children said if she'd had a stroke at night, we wouldn't have found her, and she'd probably be dead. She is, however, had her stroke at midday, and we went round and found her on the floor, and this very pristine, immaculate lady who never to be seen without, you know, her shoulders covered, her knees covered, is in a hospital with hospital gown, dishevelled, peg-fed, and we don't want that. She wouldn't want that. And so I was sitting talking to them. There were three of them. And there's two of them nodding and one shaking their head. And I went, hang on, talk to me. And they said, well, you know, we don't think it's right. We don't think she's got capacity to make decisions about her health. We want to have the conversation with the doctors about sending her to hospice, end of life care, let her die in peace and with dignity. The third sibling said no. He said, I don't agree with that. And I said, well, your mother made you the attorney. She asked you and trusted you to be that person to make decisions on her behalf in exactly this scenario. Why do you think it's not appropriate to honour her wishes? And they said, well, it's just inhumane. I mean, if she goes to a care home, she can survive for 5 years. The doctors have said that she'll survive for 5 years, peg-fed. And I said, yeah, but is that what she wanted? I said, you know, the only way we're going to resolve this is you need to be unanimous, because ultimately, you know, that's what's going to get this over the line. And we need to talk to the hospital about what a sensible and practical and pragmatic approach is. Is it go home? Is it go into a care home? And I sent them on their way. I believe they did bang their heads together sufficiently to come back and have that conversation, which was nice. But it's those discussions. Big advocate of powers of attorney. I think they're a great piece of paper. However, they are more than just piece of paper. They are roles, responsibilities and rights. And we're increasingly seeing powers of attorney coming into effect and people not understanding what their roles and responsibilities are. I want power of attorney for mum. Excellent. What does mum want? You know, so these conversations are really important, and actually understanding what your roles and responsibilities and duties are under the Mental Capacity Act are incredibly important. Which brings me on to my next sort of point. Mental Capacity Act deals with capacity. Great, 2005, you know, coming up to its 20th anniversary, fantastic. Actually, a really nice piece of legislation, if you're interested in that sort of thing. And the case law and the code of practice, which is due a revisit and due a rewrite, is actually pretty good insofar as things, but things have moved on considerably in 20 years. Society's moved on, everything has moved on. And I think the little brother of the Mental Capacity Act is the Care Act 2014 in England. There's ancillary versions in Wales, but for purposes of today, you've got Care Act 2014, which puts a lot of onus on local authorities and is often underused, in my opinion. And I think if you're working in this area, you can't really look at one without the other. Certainly the work I'm doing is explaining to people that, you know, well, if you're acting as an attorney, you're bound by the Mental Capacity Act. But you then need to go and engage with the local authority about care, funding, what that looks like, what being a carer is, because an attorney might also be a carer. And I think something I'm perpetually telling people to go and do is go and ask your local authority for a Care Act assessment. Section 9 of the Care Act, anybody who has care needs is entitled to a Care Act assessment. Section 10, their carers are entitled to an assessment. What are those needs? How are those needs met? I think they go hand in hand. If you are acting as an attorney and needing to make best interest decisions because somebody lacks capacity, where do they live? What do their residence look like? I think you need to understand that the local authority has duties. Sorry, I know they've got no money and I know they've got no time, but last time I checked, I'm supposed to pay my council tax. You know, I can't just turn around and go, do you know what, don't fancy it, haven't got time, don't really want to pay for it. Not my problem. I think I'd probably get into trouble, I think, you know, imprisoned at the end of it. So going and having that conversation and understanding those roles and responsibilities as an attorney is really important. So we come on to my current bugbear, which is paying for care. And this struck me the other day. I thought it was lovely. My siblings live abroad, leave me to care for my parents. I want them to pay me. Right, okay. You know, are we just tormenting guilt and resentment? No, he's not. He sat there and gone, oh, okay, it's actually a full-time job. It's really hard being a carer. It's really hard looking after difficult old people, you know. And mum and dad have agency, mum and dad have capacity, and mum and dad have elected not to do anything. They're living in the northeast of England, he's living in the southeast of England. Most of the family have legged it abroad, and this is his dilemma. Why should I be the one who looks after my parents for free, for nothing, when my siblings are abroad and my parents won't engage carers themselves? Well, the view is, well, they're your family, you know, there's a bit of a moral obligation at this point. And if you're interested, there was a very lively discussion on the LinkedIn feed where I posted this about this expectation of care capacity. I'm an attorney, I've got ability to make decisions. Why should I not just be able to pay myself? Well, last time I checked, I'm not supposed to do that. But this is coming up all the time. This is coming up all the time. I didn't change my slides again because I think version 3 was probably enough. There was a headline in the Times this weekend that said why inheritance bullying is rife. Why is inheritance bullying rife, one may ask? Well, we're seeing sort of people living longer, not living well longer. We're seeing people having to work longer to get to pensions. We're seeing the baby boomer generation sitting on vast amounts of wealth and not passing it down. But also we're looking at this generation having to pay for care. I was running some numbers this week, and average care costs, average care costs across country, something in the region of £1,600 a week. Depends what part of the country you are. I had a client in Bristol who was paying £8,000 a month, and that was 5 years ago. We've got people, and actually this particular care home, it was lovely. She was paying £8,000 for this most glorious sort of care home, but any time she wanted to go into the garden, they charged her an extra hour to go out and go and live there. It's cracking ways you want to go into this. But yes, this inheritance bullying is rife because care costs money. Who's paying for it? You're either getting it paid for privately or you're relying on children, other relatives, often women, you know, who've already perhaps given up time to have children, hit the glass ceiling, and then suddenly the resentment starts to build, doesn't it? The resentment starts to build because why should I have to do this? Why do I have to give up my time for my parents? I don't want to pay for care. And we'll come on to some of those issues in a bit, but I thought that really struck me. And one of the things that came out of this LinkedIn discussion was this brilliant idea of a pre-cap. What happens if you are in a relationship where you are going to end up as a spouse or a child of somebody who lacks capacity and who needs care? So Catherine's a family lawyer in Canada, and I loved this idea. You know, we should advocate for pre-caps to outline care commitments and remuneration before capacity is lost that go beyond a standard personal directive power of attorney. I think that's quite a sensible idea. If we can sit down and we can have these plans about, well, actually, if I am required, if I do need care, if I do need support, what does that look like? What does that mean? We talk about prenups, marriage, which is going to be what I'm going to come on to next, because I think at this point, the financial abuse point is very real, and capacity and task-specific capacity is incredibly important at this point. Because we then come on to Daphne Franks. I don't know if anybody's come across Daphne Franks' story. If not, she came on and talked to me, so that there is a link to the recording there. It's the most astonishing hour of my life I've ever spent listening to somebody talking about her story. And essentially, Daphne lived next door to her mum. Mum had dementia, mum lacked capacity. Daphne was in and out every day. There were friends coming around, there were people coming around to see mum. And when mum died, went to the registrar and found out mum got married. To her, pardon? What do you mean mum got married? You know, had capacity. Of course, the consequence of that, any previous will had been revoked. Test of capacity for marriage is really low compared to test capacity to make a will. New husband was delighted with his newfound wealth and absolutely dug his heels in. And Daphne, my colleague, acted for Daphne in the litigation. Her story is astonishing. And I think it's really important to understand that even though Daphne was the carer, even though Daphne was next door, even though Daphne was on site, mum still managed to get married with all the legal consequences that brought with it. Now, if that's not financial abuse, you know, And Daphne, again, it wants to use this and bring in this idea, and again, it's a Canadian notion of predatory marriage. How many of us have had clients who've long had, symbiotic relationships, husband and wife, they're doing really well, one of them dies, the other one then ends up marrying their carer or a gardener. It's always the gardener. I think, it's the housekeeper. If the man is the housekeeper and it's the woman, it's the gardener. And maybe shades of Lady Chatterley's lover, I don't know. But it's incredibly common. It's incredibly common that stable relationships, stable scenarios can unravel incredibly quickly because we have got predators out there. We have got people who are vulnerable. They may not lack capacity. They may just be miserable and lonely and difficult. There was a case reported yesterday in the paper, and again, it's a contested will case where this woman cut out one side of the family because somebody suggested while they were going on holiday to have a break that she might want to go into a care home for a bit of respite. Did not take it well. She did have dementia, but she had capacity to revoke her will and cut them out. And this relationship, obviously, we're a culmination of years of arguments about at this point, but it goes to show how, doesn't matter how hard you might work to put the infrastructure in place, it can unravel incredibly quickly. And if you have capacity, you can make unwise decisions. You can get married to somebody 50 years younger than you. You can then, but do you understand then that it revokes a will? Possibly not. And that was one of Daphne's arguments, was registrars are not being trained well enough to spot this or actually say to people, there are ramifications if you get married. We're perpetually saying to clients, there's a difference between getting married and having a wedding, a bit like, divorce and financial settlement. And we need to be better educated on this point. But I digress at this point. So Daphne's story is certainly something I think is worth following up and her campaign. Attorneys and gifting and deputies and gifting. So, mum's poorly, I'm now her carer. I've got power of attorney. How easy is it to just, slip myself 50 quid or, a couple hundred quid? Who's going to know? It's what she'd wanted anyway. And there are rules about this. In fact, there are laws about this. And, even the Office of Public Guardian, who are obviously dead keen on everybody to do their powers of attorney online with a very limited safeguarding, which as a contentious lawyer, I love. This is much more fun, when it goes wrong. Hey, drop power of attorney. Hey, revoke your power of attorney. Not a problem. I think the statistics, at the last year, the enduring powers of attorney were available. I think something like 16,000 of them being registered. Last count I looked at, lasting powers of attorney, there were 100,000 being registered a year. That's a lot of powers of attorney. They're not all coming through solicitors. They're not all coming through people. They're people going, well, it's just a form I can fill in online for mum. Sign this. I had a really obscure case this week where exactly that had happened. Somebody printed the form off for the power of attorney, got it signed, got the certificate provider who was a neighbour to say that, our donor had capacity. The certificate provider has now in a neighbour dispute with the attorney and the donor, and reported themselves to the OPG saying she didn't have capacity when I signed the power of attorney to say she did. And I was like, right, okay. So we helped the attorney out, and the right outcome was he's been appointed as a deputy. So we have the right solution in the end. But it was so easy to just looking at the forms, just like it was a tick box exercise, and it's going under the radar. So gifting, you can't gift without authority. You can do de minimis gifts. There's got to be a pattern of gifting. If not, potential. Oh no. We have criminal offences. And where there are large unauthorised payments, the OPG will investigate. And fraud, theft, offences under Section 4 of the Fraud Act, you know, these are tucked away on the OPG sites. And the reason sort of been digging around here recently, I had a quite interesting scenario where I had a phone call and client says, oh, I moved £175,000 out of my dad's account back into my account over the weekend because I had access to, you know, his app and I'm registered as power of attorney, and the bank have stopped the payment. I was like, good. And they reported me the OPG, and I went, right, probably the right answer. Now would you like to tell me what you were thinking? And he's like, well, Dad, I'd loaned Dad this money and my siblings and all I agreed that we should have it back. And I went, do you have any paperwork? Do you have any? He said, oh, hang on, I might do. Let's quickly. No, in fairness, in his defence, he did actually have letters from his dad that we were able to produce in support of the fact of his application, and his siblings were willing to do witness statements to say that Dad had made this gift, had made this payment, it was a loan. But the sting in the tail of this one was that he was a dentist. Now, why is this important? Because he's a regulated professional. And he's a regulated professional that had to report to the British Dental Society that he was under investigation. Now, when you're in a position of authority and you're in a position of responsibility, having that sort of thing hanging over you isn't necessarily very helpful. I'm sorry to say that I had a conversation with a solicitor the other day who was trying to do something, well, I'll just do this, you know, because I think he'd said, you know, he was attorney along with his mother for father, who, for tax planning reasons, everything was in Dad's name. How convenient. Dad had lost capacity. They started to go through all his bank statements, and apparently he'd been running. I think they calculated had about 100 affairs during the marriage, and a lot of money had siphoned off. And the son's like, well, I think it's important that we get the money out of his account into Mum's account, because otherwise, what's she going to do? And I went, you can't do that. I said, you can't do that because otherwise you're talking to the SRA. And he went, oh, silence. So, you know, these conversations need to be had and need to be understood in far greater context. It's not just a case of you can't do that. You can't just move money from the first direct account. There are bigger and more significant consequences for certain people. Actually, on this occasion, I said the best thing you could do is probably divorce him. You know, actually, why are you staying with him? Go for a divorce. You've got a long marriage. He's got a significant assets. Go and divorce him. Get 50%. She wasn't having any of it. She was like, no, I love him. I was like, all right. But you know, you can see how the logic came about. Thankfully, we sort of raised the flag and went, I probably don't want to do that. So yeah, one to watch. Just going to rattle through a couple of cases. They're old, but I think they are incredibly useful just as reminders. And if you haven't come across them, is the Buckley case, where we had a power attorney who decided that rather than investing money, that they would go and try and invest in a reptile breeding business, because I think it was like a 20% return. Senior Judge Lush at the time said, managing your own money is one thing, managing somebody else's is an entirely different matter. And I think that's a crucial reminder. Even though, you know, in the scheme of things, it's a 2013 case, nothing's changed. Anybody remember Gladys Meek? Yeah. Poor old Gladys. And this is another example of, you know, actually unintended consequences. So Gladys Meek, widowed, only child died intestate. Money passes up the generation to Gladys. Gladys doesn't have anybody except some, you know, conveniently newly found great nieces who go to court, do the paper application of court protection, tick, get a deputyship order, tick, and then proceed to spend vast amounts of money on cars, watches, perfume, handbags, laptops. Eventually somebody pointed out, and you do realise you're not supposed to do that, and went to court to seek retrospective approval. At which point, Senior Judge Lush went, No, absolutely not. This is not to give a licence to loot. Again, we're talking a 2014 case. It's obviously a bit of a cluster, and I know Senior Judge Lesh at the time, he had a black book of cases that he had, and he said, one of these days I was going to hand them over to the police. Because, you know, we've got all these orders. It's theft, it's abuse. We need to pass that over. I don't know if anything ever happened to it, but again, worthwhile remembering. And I think my personal favourite is Martin and Sheila, because so Sheila was in a care home, and Sheila's care home fees weren't being paid, which obviously upset the care home. And the local authority said, well, we don't understand why we should have to pay, and we'll do some investigating. Oh, turns out there's an attorney. How convenient. Martin, Sheila's son, was having an argument about NHS continuing healthcare funding. Said, I don't think my mum should be paying for her care fees. I think the NHS should be paying for it. So that's why I haven't paid care fees. A little bit further digging. Turns out Martin's charging his mother £400 every time he goes to visit her because he was a financial advisor. And that's what he did for all his clients. You know, yes, 117,000 is an excessive amount of out-of-pocket expenses. More strongly than that, it's repugnant. And I think that these need to be remembered when people are going, but I've got this piece of paper that means I can, you know, go online, I can go on the app, I can shift money around. Who's going to notice? People do notice. So I'm a member of STEP, was involved in their campaign, safeguarding campaign. I'm not going to read those out, but it's really important that actually we are increasingly seeing problems with power of attorney. And as I say, I quite like, a bit like, you know, I love a homemade will. I like a homemade power of attorney because chances are there's going to be a problem. Or, you know, a homemade a DIY de-verification. Always a pleasure as well. Huge amounts of statistics really showing there's a massive uptick in people not understanding it. Could be societal, could be just, you know, accessibility, could be actually just how easy it is to just move money around. 3 lovely headlines. You know, defrauded mother of 60,000, wicked carer used frail pension as a cash cow to plunder £300,000 and fled to Tenerife. Todd Morden man who defrauded an elderly mother out of a £100,000 sentence. Finally, we're getting to the point where this is theft, this is fraud, this is criminal law, there are sanctions. But, you know, sometimes I sort of, you know, get quite aggravated and want to start, you know, amending the headlines. Can you not, like, stole? Not like, you know, plundered. It's like, no, really, you know, you stole £300,000. It's coming out more and more. Every week I'm seeing more and more headlines about this, and it's worrying in a sense, why there is this sense of entitlement, why we have Martin and his mother Sheila with his, you know, entitlement to £400 a day, why we have Gladys Meek's children going, the licence to loot. It could be that we've got, well, we've always had intergenerational wealth transfer. My parents didn't really work for it. They've just been lucky because of the housing market. You know, I'm not so lucky. My kids aren't so lucky. They need money for a deposit. My parents are standing in a massive house. They don't need it. My kids do. Who's going to notice? It's going to come to me anyway. And it's going to come to me anyway is a conversation I have far too often with people. Like, I guess, but just mother's not dead yet. You should know that, don't you? Oh, well, you know, she's in the care home. Well, why should I have to pay for care fees? I went, because you have to. Because if she's self-funding, then she has to pay for care fees. And, you know, if you're fortunate enough that £2,000 a week care fees for an unlimited, an unknown time frame doesn't bother you, then all power to your elbow. And if you've got so little money the state pays for you, again, you don't have a problem. The 95% people in the middle? Yes, it is. And that go back to that very first slide about the frailty point. There's a dip. there's a, oh God, they've gone into hospital, they're going to die, it's all awful. And it's that sort of point where you go, oh God, that's it, this is it, curtains. And then they rally. They go dead cat bounce. Where you get that point where you go, actually, they've gone in hospital, they're fed, they're warm, they're well, they move into a care home, and they stabilise. They stabilise, they're not well, they're not going to be running marathons, but they are still alive and still need care and still need maintenance. Now, we can argue till the cows come home who should be paying for that, and I regularly do. But if you are not covered by the NHS or the state because you have so little money, then care is being paid for, and 'twas ever thus since the inception of the NHS. Sorry, I hate to break it to you, but you know that's it. To this point, I say to people, you know, when the state pension was first introduced, the life expectancy was 3 years. It's now 30 plus. So, you know, we are not keeping track with what this problem is, but that's for another day. If you're interested in the Spot the Signs campaign, do have a look at it. There's some really interesting resources in there, including me pontificating about, you know, why people buy lawnmowers when, you know, mum doesn't have a garden, you know, or how suddenly mums was shopping in Waitrose and is now shopping in Asda. You know, this financial abuse can be subtle. It doesn't have to be as big as that, but it's worth having a look at it. And again, just for sort of vulnerable client stuff, there's just a bit of a selection of things there that I've found really useful in practice lately and in general learning points, because, you know, this is a problem. This is increasingly a problem. If we need people to be involved in court proceedings, they need to be able to participate. We need to look at safeguarding issues. We need to look at what we do for vulnerable customers. So these are all very worthwhile. And finally, that's me, my somewhat eclectic, or as somebody said, eccentric practice area, which is court protection, private client and care fee funding, or SHOTI private client, as I like to call it. And yeah, very happy to take any questions now or later. And if you don't follow me on LinkedIn, please do, because it's quite a chatty space and get quite a lot out of it. Okay, cheers.
Thank you, that was
You're welcome.
Thank you.
Are there any questions?
Any questions?
Okay.
Oh, there is one.
Ooh. So there's a court case. Have you seen it recently? And I can't for life remember what it's called. Maybe somebody here will remember what it is. Where there's been a contested will, and Rita, you going to remember what it's called? No, okay. You're new. Anyway, it'll come to me, and I'll send it round. Where the contested will has been about. Well, I looked after mother, and we agreed as a family on the WhatsApp chat I would get paid. And as His Honour Judge Matthews, who's down in Bristol with us, said, okay, yes, we agree to the contestant. The quantification of the care fees hasn't come through. It raises a really interesting point, because it's, what is the family expectation? Is there a contract? Are the parties capable of entering into a contract? Does mum as donor of does mum have the capacity to enter into a contract to pay her child? But did she say she wanted to pay her children to do it?
Still got capacity. So she's still got capacity.
Yep. Yeah. And it's the gratuitous care payment point, which, you know, what you can and can't approve. But then I think it's different if you've got a deputyship, which might be a crisis sort of purchase, rather than an attorney, which is, well, we thought about this, and I want to be cared for at home. Did mum know or understand what being cared for at home meant? It's not a sort of Doris Day sort of lifestyle of, it's fine, I'll feed you a cup of tea. What if you need, 24/7 care, hoisting, manual handling, all that? So, yeah, it's bubbling, and it's going to explode if it hasn't already. So. Yeah, hi.
Question on the statement is those headlines around yeah, yes, 100% fundamentally wrong. What I found with my clients that I'm setting up how to pay, some of them are scared of those headlines and are actually using that as a reason why they shouldn't set up a marriage day. And I'm like, well, you need to trust children, for example, and if you trust them, then those headlines are exciting. And then kind of the response is, well, those people have set those up, the man who scammed £2,000, whatever it was, she trusted that time. So it's, I worry that, yes, we can't highlight these cases of misuse, is that they're going to be a fearmonger for those good cases that you have a lot of planning.
Possibly. There is an argument to say if you don't trust your children, or you know that they are problematic, you shouldn't be choosing them. If they go rogue, then it's what supervision and oversight do they have? Very precious little at the moment. There's, I have had the conversation with people going, well, I thought I could do this. So did you read the power of attorney? Did you read your what you had to do under the Mental Capacity Act? I went, nope, never seen it. I went, see this page with your signature on it? See this bit beforehand? They went, okay, yeah, fine. So, it's a trust thing. I was at, it was Action and Elder Abuse conference, now Hourglass, where Senior Judge Lush did stand up, and I was in the room when he went, I would never do a power of attorney. And the reason I would never do a power of attorney is because I would want to go through the court of protection, because there's annual reporting and oversight.
Yeah, sometimes court of protection is the answer.
Yeah.
I've said to people, just don't do it. Court of protection. Well, that's terrible. No, it's not. Because maybe that's the same.
Yeah.
You shouldn't be channeling people into one particular course and other alternatives available. There is an alternative.
Yeah.
Like the Senior Judge of Court Protection said in
Yeah.
The course of it.
Yeah. Hi.
I was just going to say, we tend to do it, but it is possible for attorneys to have an equivalent bond to reject the bond.
Yeah.
And I struggle to understand why that hasn't become part of the OPG's registration process. Because yes, the majority of attorneys behave well, or don't need to behave at all, and it's only a small minority. But for every LPA that is registered, if there was £5 bond premium paid, then it would cover the loss that is incurred by a donor over the course of the.
There is work being done around this. A lady called Lynn Coons.
There are so many more alternatives in place. But I'm a member of the panel, the OPG's panel, and although most of the supposed to use their position, it doesn't feel like that work, because most of the work that we are referred is our financial abuse cases where
Absolutely.
there isn't a figure, if it's an attorney there's no bond, if it's a deputy there is one, and it's extremely difficult to get a bond called in, and then the bond company to pay out, and then if there's no bond in place, trying to recover money from an attorney that's done a bond is.
That's why you have professional attorneys. We come with indemnity insurance.
But that'll not really be answered. Those people where they're angry about having certain thought, but certain people having thought about having a professional attorney on the side.
Don't want to pay solicitors.
you're not winning.
then you have got that recourse to court. Then there is always the option, do nothing, because there is a backstop. Yeah.
What's the bar?
Oh, Howdens.
So then, correct, and the judge will set the bond depending on who your policy, if you want A, how much the estate is and what is it. It's a very useful tool.
Are they saying double down?
I'll let you know that.
Just make it.
I'm sure you're all desperate for coffee, so if you do want me, I'm around for 10 minutes or so. Thank you.